This is the directive: financial autonomy, coercive debt, participation integrity, and the institutional duty to protect. There is a dangerous misconception embedded deeply within safeguarding systems. A misconception that continues to destroy lives quietly, invisibly, procedural, and often lawfully. That misconception is that financial harm is secondary harm, that debt is separate from abuse, that credit destruction is an unfortunate side effect, that housing insecurity is merely economic difficulty, that banking systems are neutral, that mortgage enforcement is administrative, and that financial collapse sits outside safeguarding. But financial destruction is not secondary harm. It is often the mechanism of control itself. And until institutes fully understand that financial autonomy, financial safety, credit integration, housing protection, and economic dependency are safeguarding issues, then safeguarding itself remains incomplete. Because autonomy without financial autonomy is not autonomy at all. And participation without economic survival is not meaningful participation. Today I want to speak about the safe chain framework architecture in full detail, and especially how these frameworks intersect with coercive debt, mortgage vulnerability, FCA obligations, banking accountability, financial remedy abuse, credit file destruction, and the institutional reality that economic abuse has become one of the most operationally protected forms of harm in modern society. Because the truth is this: a person can escape physical violence and still remain trapped financially for decades. And the institute, in fact, for many institutes still treat that financial destruction as a private inconvenience rather than a safeguarding failure. That is no longer acceptable. The safe chain framework suit was built especially because fragmented systems continue to fail vulnerable people operationally, not symbolically, operationally. The frameworks exist because safeguarding has become performative instead of enforceable. Policies exist, procedures exist, training exists, but protection often does not exist. And that distinction is the entire reason these frameworks exist within SafeChain. The SafeChain framework suite establishes a fully integrated safeguarding infrastructure, not awareness, not guidance, not another report, but infrastructure, the complete Self-Chain TM framework register includes participation integrity TM, doctrine MOPIT TM, model of participation integrity, CPIT TM, compliance in practice oversight, SIP TM, system intervention protocol, SIP TM, safeguarding participation integrity protocol, local authority and housing framework. These are systematic safeguarding frameworks. The paradox of the part-time judge framework, body first, language TM, the threshold TM, rebuild TM, and the campus TM. We have the RISE TM and the integrated safeguarding infrastructure itself. These are not disconnected modules or models. They are interoperable operational doctrines. Each framework closes a different safeguarding gap. Each one addresses a different failure point within institutional systems. And together they create continuity, because continuity is the missing element in every or almost every safeguarding collapse. The first core doctrine is participation integrity TM. Participation integrity TM recognizes a truth that systems continue refusing to operationalize. Presence is not participation. A traumatized individual may physically attend court meetings, assessments, banking appointments, housing interviews, safeguarding reviews, or financial remedy proceedings, while being psychologically incapable of meaningful engagement. And yet, institutes continue recording participation achieved. That is false participation. Participation integrity TM establishes the principle that participation must be informed, supportive, psychologically capable, procedurally equitable, and operational reality instilled in the process, not merely recorded. This doctrine becomes critically important in financial systems because cohesive debt operates precisely through impaired participation. Victims frequently sign agreements under coercion or coercive consent. Under fear, they accept unaffordable liability. Under psychological exhaustion, they fail to challenge defaults because of trauma and loss of housing, while institutes continue treating every procedural step as valid. Self-Chain rejects that model entirely because a procedural valid injustice is still injustice, and this principle sits at the heart of CPITTM, which is a compliance in practice oversight. CPITTM exists because policy is not protection. This framework converts safeguarding from institutional self-reporting into enforceable practice integrity. Not was there a policy, but did the policy protect the person? There's a distinction. Not was training delivered, but did the practitioner apply it correctly? Not was a process completed, but was the outcome safe, proportionate, lawful, and protective. CPITTM establishes operational accountability, not symbolic accountability, and this becomes critical when examining banking systems and coercive debt, because banks often defend themselves using process. They say affordability checks were completed, forms were signed, mortgage conditions were met, notices were issued, debt recovery procedure was followed. But CPITTM asks the question institutes rarely want asked: did the process protect the vulnerable person? Because if the answer is no, then the existence of procedure becomes irrelevant. This is where the self-chain TM financial safeguarding doctrine becomes essential. Economic abuse is one of the least operationally recognized forms of domestic abuse, despite being one of the most devastating of them all. Economic abuse includes coercive debt, financial dependency, restricted access to money, manipulated affordability, hidden liabilities, destroyed credit rating, forced defaults, mortgage sabotage, utility debt, fraudulent joint liabilities, coerced guarantees, and strategic financial exhaustion. Many victims leave abuse or abusive relationships only to discover destroyed credit files, unaffordable liabilities, mortgage arrears, CCJs, fraudulent borrowing, and years of economic damage. And yet, institutes frequently continue creating or treating these situations as standard debt recovery matters rather than safeguarding emergencies. This is the operational failure. The FCA customer duty changed the legal landscape significantly. Under the FCA consumer duty, firms are required to avoid foreseeable harm, support vulnerable customers, communicate clearly, and deliver fair outcomes. But SafeChain identifies the central operational problem. Vulnerability is recognized theoretically, but not operationally, and is not operationally integrated within the systems. Banks may identify vulnerability while simultaneously continuing enforcement activity that worsens the harm. This creates what SafeChain calls procedural contradiction. For example, a bank may recognize domestic abuse, place a vulnerability marker on the record, note psychological distress, acknowledge safeguarding concerns, while simultaneously continuing debt escalation, and they refuse mortgage flexibility, allowing the coercive liability to remain enforceable or enabling enforcement pathways that result in homelessness. This is not safeguarding. This is institutional fragmentation and lack of visibility. And fragmentation is where harm survives. SafeChain, therefore, introduces the concept of financial participation integrity. This means financial systems must recognize that trauma affects decision making, coercive affects consent, fear affects communication, exhaustion affects procedural capacity, and economic dependence affects autonomy. A mortgage agreement signed under coercive conditions cannot automatically be treated as freely entered participation. A debt accumulated through abuse cannot automatically be treated as ordinary consumer liability. A destroyed credit file resulting from coercive control cannot be treated as neutrality or a neutral financial history. The financial system must therefore become safeguarding, aware, operationally protective of the victim, not cosmetically. This is where SafeChain intersects directly with FCA regulations, credit references or credit reference agencies, mortgage enforcement, housing systems, and financial remedy proceedings. Because the current systems operates on a dangerous assumption that financial systems are neutral. They are not. They are not neutral. Financial systems determine housing access, employment access, mobility recovery, stability, healthcare access, and long-term autonomy. A destroyed credit file can keep someone trapped for years. A forced repossession can create generational instability. An unaffordable debt burden can psychologically destroy a survivor long after the abuse itself ends. This is why SafeChain identifies financial protection as a safeguarding obligation, not an operational welfare issue. Mortgage protection becomes especially critical during this period. Under SafeChain, housing is not merely property, it is participation infrastructure. Without stable housing, procedural participation collapses, recovery collapses, emotional regulation collapses, and safeguarding collapses. This is why the local authority and the housing framework exists. This framework establishes operational housing continuity, safeguarding linked housing assessments, trauma-aware enforcement review, proportionality analysis, and participation protection during housing proceedings. SafeChain especially reinforces Article 8 ECHR, proportionality principles, housing vulnerability law, and the requirement that institutes consider safeguarding impact before enforcement action. Because eviction without safeguarding continuity is not administrative neutrality. It can become institutional harm. And institutions can no longer hide behind fragmented accountability structures. SafeChain also directly addresses credit reference agencies. Credit agencies hold extraordinary power over human autonomy. Yet, safeguarding obligations within credit systems remain dangerously underdeveloped. A survivor of domestic abuse may carry coercive debt, fraudulent borrowing, strategic defaults, manipulated joint liabilities, or financially abusive account activity for years. And the credit system often records this without context. The result is institutional continuation of harm and of abuse. SafeChain therefore proposes safeguarding linked credit integration protocols. This includes vulnerability linked credit review, coercive debt assessment mechanisms, safeguarding flags, enhanced dispute systems, and financial recovery pathways. Because credit reporting cannot remain blind to abuse while claiming neutrality. Neutrality without context becomes harm. The same principle applies to mortgage lenders. Mortgage providers cannot continue treating coercive debt, financial abuse, participation impairment, or safeguarding risks as irrelevant to affordability and enforcement decisions, because the outcome of enforcement may be homelessness, re-traumatization, psychological collapse, or operational exclusion from justice itself. SafeChain therefore reframes financial institutes as safeguarding participants, not detached observers. The frameworks also establish accountability chains. This is one of the most important concepts within SafeChain TM. It diffuses accountability is one of the greatest enablers to institutional harm. Everyone says that is not our department, that is not our remit, this is not our decision, that sits elsewhere. And so harm survives within the gaps. The accountability chain principle rejects the fragmented responsibility entirely. If a safeguarding concern was identified, vulnerability was recognized, financial harm was foreseeable, and operational intervention was possible, then accountability exists, not morally, operationally, and legally too. This is why self-chain frameworks establishes audit trails, evidential continuity, escalation structures, participation standards, outcome integrity requirements, and enforceable accountability mapping. Because safeguarding without accountability is theater. One of the strongest operational principles within the frameworks is practice over policy. This principle establishes that written procedure is not proof of operational integrity. An institution cannot rely upon policy existence, training slides, strategy documents, aspirational statements, or procedural templates as evidence that safeguarding actually occurred. The only relevant question becomes, what happened to the person? What happened to the person? Were they protected? Were they stabilized? Did the system reduce the harm, or did the system reproduce the harm? Self-chain therefore moves safeguarding from symbolic compliance to operational outcome integrity. This distinction changes everything, because institutes are currently rewarded for activity rather than protection. Self-chain changes the metric entirely. Not how many referrals were made, but how many people were actually protected. Not how many assessments were completed, but did the assessment reduce harm? Not was procedure followed, but was justice delivered? This is the future standard. And this is deeply, deeply connected to financial autonomy, because a person cannot meaningfully rebuild while buried beneath cohesive debt, excluded from credit access, denied housing stability, and procedurally trapped within the financial collapse. Self-chain therefore recognizes economic recovery as safeguarding recovery. Financial protection not separate from dignity. It is dignity. Autonomy is not abstract. It is materially dependent upon financial stability, housing continuity, credit restoration, and operational protection from institutional harm. This is why self-chain integrates safeguarding finance, housing, participation, and constitutional protection into the interoperable system, because fragmentation is what allowed the harm to survive in the first place. And this is ultimately what the directive becomes. Not commentary, not awareness, not report, not theory, but operational architecture and an enforceable safeguarding infrastructure designed to close procedural gaps, protect vulnerable people, restore participation, enforce accountability, and rebuild institutional integrity from the ground upwards. Because safeguarding must now mean continuity, enforceability, accountability, interoperability, and operational truth. Not aspirational, not branding, not performative, and certainly not procedural theater. It needs to be effective and not disguised as justice. This is the future direction of SafeChain, the future direction of safeguarding, and the future direction of institutional accountability itself. Thank you.